NACDL is the Association of the Nation's Criminal Defense Bar.
So this panel is entitled Forgetting, Alleviating Collateral Consequences Through the Legislative and Referendum Process. So we have three great panelists who are going to be talking about some of the legislative reforms to relieve collateral consequences. To my immediate right, we have Marissa Dodson. She is the Public Policy Director for the Southern Center for Human Rights. To her right, we have Desmond Mead. He is the president of the Florida Restoration of Rights Coalition. And at the end, we have Reid McGrath. He is the managing attorney for the Minnesota office for the Institute of Justice, as well as their senior legislative counsel. I'm going to give each panelist kind of 5 minutes to give further introductions. Their bios are in your materials, but just for them to introduce themselves, their organizations, and a brief highlight of some of the things they're working on before we get into questions. If you have any questions as we continue the discussion, I would just ask you to stand at the mic so you can be recognized. So we'll start with Marissa.
Great. Good morning again. Can everybody hear me okay? I am the Public Policy Director at the Southern Center for Human Rights, but I have spent my entire legal career, it's 10 years next month actually, committed to criminal justice reform. For the first 7 years of my career, I spent it at Georgia Justice Project, whose entire staff is here today. They've closed the office to be here. And at that organization, I was an Equal Justice Works fellow. And Equal Justice Works is a national organization that partners first-year attorneys with an organization to work on the project of their choice. It's funded by law firms and foundations and individuals. I got an opportunity to have a 2-year fellowship to start the first program in Georgia committed to this very issue around addressing collateral consequences of an arrest or conviction in Georgia. The program was 3-tiered. One of the tiers was policy, and that really was, kind of at the height. Governor Deal, who was here yesterday, mentioned that he was campaigning in 2010 and took office in 2011, and it was just perfect time. It was about 3 years into my practice where the state, through its executive leadership and legislative leadership, began to be committed to criminal justice reform. It took them a few years to get to reentry, as he mentioned yesterday. So the first couple years were spent on trying to send less people to prison, both adults and children, and then that third year is the year that we said we focused on reentry. I, though, want to kind of take a step back from what we think about when we're talking about reentry, and it kind of segues into the role I have now at Southern Center, which is to think about not just reentry after conviction, but reentry to a system after encountering the system. So what does it look like once you have been arrested and once you are before conviction? So any encounter with the criminal justice system, I would argue, there is a reintegration in terms of how you might be able to move on in your life when it comes to access to opportunities. So I only say that because I think while we always think about criminal records and moving into employment as the only time when we should be thinking about reentry, I would venture to argue that when we're thinking about pretrial justice and with the way in which folks are encountering the system at the beginning, that has an incredible impact on one's ability to successfully reintegrate at all. So I was involved very closely with the administration's efforts around improving access to opportunity for folks with records. We significantly changed our expungement statute in 2012. You may be surprised to know that in Georgia, if you were found not guilty of an offense, you are not eligible to have the record restricted from your criminal history. So we would have clients who would, exercise their constitutional right to trial, and we know how difficult it is as criminal defense lawyers to take that kind of risk. But even when acquitted by a jury of their peers, they still moved through their life with those records. So the state changed, and not only was the access to expungement very limited in Georgia, but the process could last years. So we're talking about folks who would come into the office and say, this employer says, so give me a job right now. Just get this off my record. You have to say, sorry, right now in that county, it's taking about 2 years to process expungement applications. So I say that to say, through changes to our expungement statute, we still have such a long way to go. Governor Deal he didn't even mention this yesterday, but we were the first state in the Deep South to implement ban the box on state employment applications. He took the lead. And in a meeting with the Georgia Justice Project when I was still there, we actually suggested that he lead by example. So there was some concerns, and there are legitimate concerns, I think, with what kinds of inroads you make with the business community here. And he was concerned that he didn't want to seem coercive. So what better way to do it than to say we're leading by example? There's still a lot more to go there. The state has done things around employment protections. As he mentioned yesterday, we eliminated the food stamp ban for felony drug convictions several years ago. We are now in line with the federal guidelines for child support, in that incarceration is a factor that can be considered when you're thinking about what appropriate income is for modifications to child support. So I say all that to say we have done a lot of things in Georgia to be proud of when it comes to thinking through the impact of a criminal record, but there is still a very long way to go. Lastly, I'll say my work at the Southern Center, as I mentioned, is much more comprehensive. We are engaged in everything from getting a traffic ticket, which in Georgia, every single traffic ticket is a misdemeanor offense, through the implementation of the death penalty. We work on bail, we work on isolation, we work on mental health cases and pretrial conditions and post-conviction. We work on racial bias and jury selection. We work on intellectual disability when it comes to the protections of those individuals from execution. So there are a range of ways that the Southern Center is engaged in these issues and trying to impact change in Georgia.
So good morning, everyone. We have to try that again. Let me see what time it is. It's 9:43. Y'all should be up by now. Good morning, everyone. Good morning. All right, that sounds a lot better. My name is Desmond Mead. I am the president or the executive director of Florida Rights Restoration Coalition. It's, I would say, the leading organization in the state of Florida that is comprised of directly impacted individuals or people with prior felony convictions, as well as family members of those who've been incarcerated or have had a negative interaction with our criminal justice system. I am also the chair of Floridians for a Fair Democracy, which is the ballot committee that was formed to sponsor a constitutional amendment that would restore the ability to vote to approximately 1.5 million Floridians in Florida. While at the present there's not much to brag about as far as policy-wise in Florida, there are some things to be hopeful for with our ballot initiative, but also with the people that we have there, right? And so the Florida Rights Restoration Coalition, like I said, is an organization that's led by people who have prior felony convictions and doing an amazing job and really changing the narrative about who a convicted felon is or what they look like. And I definitely want to highlight one of our members, Jody Polk, who is also a Soros Justice Fellow, right? And then we have amazing allies like the great Carlos Martinez, who is a public defender for the 11th Judicial Circuit. And so if there's anything to be happy and hopeful about in Florida, it's people like those two allies like Carlos and returning citizens like Jody, who collectively have brought Florida to the brink of entering into a more modern system. And what I mean by that is that we are less than 80 days, actually less than 75 days away from actually striking a fatal blow to Jim Crow by getting rid of this felon disenfranchisement policy in Florida. And so just to give just a little background, because I'm going to be mindful of my time, we, in 2011, we knew that something had to be done because prior to 2011, we had a policy that automatically restored voting rights, or civil rights actually, to individuals once they completed their sentence. And we had a new administration come in 2011 that made it extremely more difficult. Just to give an example, under Governor Jeb Bush, approximately 75,000 people were able to have their civil rights restored in a period of 4 years. And then under Charlie Crist, Governor Crist, approximately 155,000 people were able to have their civil rights restored in a period of 4 years. Under this current administration, in the past 7 years, approximately 3,000 people have been able to get their civil rights restored. And so we've seen the number of citizens who have been disenfranchised from the system grow to over 1.68 million, which equates to a population of over 15 U.S. states and territories and approximately 50 to 60 countries in the world. And so we knew that when it came to something like voting, voting is closely tied to power. And when we're talking about the issues that directly impacted individuals in reentry or even in the criminal justice system, we knew that there were service delivery approaches to dealing with the issue, and they also knew that there were policy changes that also had to occur. And the thing that connected both of those or enabled either one of those things to be effective was the ability to have power. And the ability to have power rests in the ability to vote. And so we knew that nothing speaks more to citizenship than voting. And so we, at the minimum, had to restore the ability to vote to formerly incarcerated or convicted individuals and have them be a part of the process of changing the conditions which they were forced to live in. And so that's what we set about doing through a ballot initiative that has always been centered around directly impacted people and led by directly impacted people. And we started a grassroots movement that made history by being able to collect over 80,000 petitions to trigger the Florida Supreme Court review. We did that with no money, no major organizational backing, pure grassroots effort. And when we got before the Florida Supreme Court, we did another amazing thing by being able to secure a unanimous opinion that gave us a green light to continue collecting petitions and place this initiative or referendum on the ballot. After that, we had to collect 1 million petitions in 5 months. And if you're familiar with Florida, that's a huge state, a lot of ground to cover. And we gave ourselves 5 months to collect 1 million petitions. And we actually exceeded that goal in less than 5 months with a volunteer effort that accounted for over a third of those 1.21 million petitions that were collected. And in January 23rd of 2018, this year, we were officially certified to be placed on the ballot. And we, now our amendment number is 4, amendment number 4, so we're voting for second chances. And we have been polling extremely well in the state of Florida, extremely well. And so the reason why I mention that is because I think even in discussions of criminal justice reform and whatever angle you come from, it is so easy to lose ourselves in the disproportionate impact that it has on the African American community or people that are incarcerated, that we end up excluding a large section of individuals who are also adversely impacted by the criminal justice system. I.e., in Florida, we have over 1.68 million people who can't vote. Most people think the majority of them are African American. But the reality of it is that over 1 million of that 1.68 million, all right, don't look like me. They look like this guy sitting next to me, to be real. And then the other thing is that Florida, while we might convict approximately about 170,000 people each year of a felony offense, less than 25% of those individuals are even sentenced to prison. And so we have a population 75% of the people who are convicted of felony offenses, right, that guess where they are? They're in our communities, they're in our homes, they're in our churches. But the conversation's always centered around the people who are incarcerated, right? And then always centered around African Americans. So what we've done in this movement that I love is that it created a sense of inclusiveness, right? And we organized around love instead of fear, knowing that this issue, while it was, when you talk about felon disenfranchisement, while we know that it was initially intended to adversely impact the newly freed slaves, like a tumor, it has spread across their body and now has affected all aspects of our society, and therefore has now really become an all-American issue. And in doing so, it has allowed us to organize across racial and across political lines. And we've done it so successfully that we are now polling over 60% with Republicans. And that's unheard of on an issue when it deals around voting rights. And so that, just want to end with that our approach is an approach that believes that if we have these discussions more along the lines of humanity, right, and not limit ourselves or box ourselves in from the very beginning, then we're able to impact more lives. We're also able to include more warriors to this fight. And so it won't just be a room full of bleeding heart liberals and African Americans, and it would be conservatives up in here, just as much conservative, and we'll have white folks from rural areas who have been caught up in the opioid crisis, and this would be a hodgepodge or a smorgasbord that is more reflective of the demographics of this country. Thank you.
Good morning. The Institute for Justice is a public interest law firm headquartered in Arlington, Virginia, and we cross paths and have common ground with the NACDL in 3 areas. The first is that we are the nation's leading advocate for ending civil forfeiture. The government shouldn't be in the business of taking your stuff until after you have been convicted. Secondly, we also share a desire to reduce fines and fees. In the October term that is coming up, my colleagues will argue a case, Timms versus Indiana, to the United States Supreme Court. And the question before the court is, there's one remaining part of the Bill of Rights that has not been incorporated against the states, and that's the excessive fees clause. And so my colleagues will argue that that component of the 8th Amendment should be incorporated against the states through the Due Process Clause and the Privileges or Immunity Clause of the 14th Amendment. And then finally, the third area which we share a common interest and a common determination with NACDL and others is to reduce barriers, reduce the size of walls. And in particular, it's about getting people back to work. And one of the biggest barriers, one of the highest walls, are occupational licensing laws. Occupational licensing is the biggest labor institution in the United States today. About 25% of all Americans need the government's permission before they can work. That is bigger than the 11% who are union members and the 2% who earn the minimum wage. And embedded in these numerous, nearly over 1,000 occupational licenses across the country are 6,000 blanket bans. If you have a criminal record, you can't even apply for a license. So in today's discussion, I hope to engage you in figuring out a way to get rid of these bans and to make it easier for people to take that first step onto the economic rung of opportunity by reducing the barriers to gaining an occupational license. Monica, thank you.
So thank you to our panelists for those introductions, and a lot of them touched on some topics that we're going to be exploring today. And I want to start with Marissa because she mentioned Georgia being the first state in the South to ban the box. So I want her just to expand more on how you were able to do that, what coalitions you were able to build, and the kind of the legislative strategy that you used to get that done.
I absolutely be delighted to do that. Where's Pamela? Pamela Wynn, yep. So Pamela Wynn is, her mother is an advocate and has been an advocate. She's a formerly incarcerated woman. Her name is Marilyn Wynn, and she started the Ban the Box campaign in Atlanta. She would say that she wasn't thinking through, what ban the box in terms of this phrase. She just knew how hard it was for her when she came out of prison to get a job. And so she worked in coalition with, she worked for 9 to 5 and built a coalition of local organizations to get local jurisdictions like the city of Atlanta and Fulton County engaged in discussions around banning the box on their applications and following a national trend in thinking about hiring discrimination in a different way. And it was because of that kind of leadership at the local level and the conversations around reentry and cost on the system that were going on at the same time. Georgia it's 1 in 3 people in the state have a criminal record. I actually say it's much higher than that, because that number includes children. We take our population of people, we take the 4 million or so folks with records, and then we say, oh, that's about 1 in 3. Well, actually, if you think about children under the age of 17, it includes, so it's more like 50%, right? So when you're thinking about what kinds of opportunities folks have to really take care of themselves and lead productive lives, this was an intersection point for fiscal conservatives who were interested in the phrase turning tax burdens into taxpayers. So with 95% of the people coming out of that are in prison coming out, with more than around half of the adult population having a record in Georgia, with local jurisdictions entertaining conversations around ban the box and passing that legislation. Governor Deal, when we met in his office and we were able to tell him, here are some reasons why these kinds of policies make sense. Here's what's going on around the country. Here are policies that have been passed in jurisdictions with high populations of folks with records. The sky has not fallen in. Folks are, we're not seeing public safety concerns in the city in the way that we thought, or the way that had been kind of perpetrated by the other side. And so, as I mentioned to you, this conversation of what ban the box might look like for Georgia was to set the example for the private sector. And I kind of want to continue to reiterate, and Governor Deal's point yesterday around the private sector piece here, because private employers in Georgia can still and do still ask the question about criminal history on the application. We continue to have a need for a private ban the box like many states have done. But we do have, and to your point, Lee, we did pass ban the box for licensing, for occupational licensing. So now in Georgia, not only is do you have a better opportunity for state employment, but you also have an opportunity for occupational licensing in ways that you did not before.
I want to give Lee a chance to kind of explain some of the occupational licensing reforms that IJ is working on. I know they have actually a model bill that they've been kind of working through the states, and it's been, I would say, very successful this past year and last year. So I want Lee to talk about some of those occupational licensing reforms, what's included in the model, and how it's been received in the various state legislatures.
Thank you, Monica. Yesterday, Dr. Pryor repeated a phrase that is often attributed to FDR. It is the idea that the best social program is a job. And so our model builds upon that concept in a couple of ways. One is that it eliminates, it's a process bill. It's a piece of legislation that instructs licensing boards to engage returning citizens and give them a process in which they can apply for an occupational license. First and most important, it preempts all mandatory bans. And so other places in state law that say a person, because of a criminal record, cannot even apply, that is preempted by this model. Secondly, it restricts the board to only look at a few things. They can only look at felonies and violent misdemeanors. They can never use and never consider in the application process arrests without a conviction, expungement or pardoned convictions, juvenile adjudications, diversion programs, or most felonies that are older than 3 years. The third component of this bill is what every lawyer will appreciate. It flips the burden. You should not have to go into court and prove the negative. You should not have to go into court and prove that you won't do it again. Instead, the burden should be on the government to prove that your past really is predictive of your future, and in such a way that that you should be not denied the opportunity to even apply for a license. And so part of flipping the burden is to establish the standard of proof, which is that the past conviction must be directly, substantially, and adversely related to public safety. And the thing that has been most popular, the fourth component of this bill, is timing. You should be able to go in front of a licensing board, go in front of the Department of Labor at any time before, even including before you have gained the requisite training to qualify for the license. This component, this final fourth component, is so intuitive that state legislators open their eyes to the absurdity of the current system and say, we should get the government out of the way of people applying for a license and allow them to gain some sort of recognition that they can take to the cosmetology school, that they can take to the community college where they'll learn welding, so that when they come out, they can get that requisite license. On July 2nd, Governor Sununu in New Hampshire signed SB 589 that thanks to the work of people like Margie Love and others, was nearly verbatim to IJ's model. 10 states have implemented this type of process, and as Margie pointed out yesterday, they're not your predictable states. They are Indiana, Kansas, Tennessee, and Wisconsin are the leaders among those 10 states. So we have had, Georgia has done this as well. It is one of the 10 states. But one should not guess where state legislators are going to fall based on the R's and the D's after their names.
Lee, can you further talk about which, if any, components are more popular than others, and then what kind of reception you've gotten in the states? If there's any hesitations, what that's been?
The component that is most intuitive is being able to go in early. The component that most is powerful to lawyers is flipping the burden to the states. Who objects to this? Licensing boards. Licensing boards are captured by industry. And licensing boards have the patina of protecting the consumer. In reality, they protect licensees. They are the biggest anti-competitive institution in America, designed to keep people out. And, well, thank you. And so, understanding that power has, you speak about power. Well, power can show up in lots of ways, including regulatory capture. Fortunately, this is such a compelling and intuitive idea that people should at least have a chance, a second chance, that this type of model is well received and continues to be well received.
If there's, if you don't mind sharing, like what states you envision IJ working in, I know there's a lot of folks, advocates in the room who would be interested if you are planning to come to their state anytime soon?
This is easy legislation. This is not hard. And so we are open to working with everyone and anyone across the country. It really is just asking the legislators to give people a second chance and to have them stare down some bureaucrats on occupational licensing boards. It would be terrifically fun to work in California. In California, there are currently inmates who are fighting fires, but when they are risking their lives to put out fires, when they get out of jail, there is a permanent bar against them getting the necessary license to continue to fight fires. We would like to change that.
Thank you, Lee. Desmond, I want to jump back to Ban the Box real quick because I know Florida does not have Ban the Box. Is that correct?
Yeah, that's right. We have several counties and cities that have passed various levels of Ban the Box, but we haven't done anything statewide yet.
Can you speak on what the holdup has been, what the problem has been, or the pushback?
I know, because you were talking about where can we go with this legislation. I would like, in my head, I'd like to see them try to come to Florida with that, because Florida is a tough cookie to crack. I mean, it's actually 3 states in one, and so our legislature is, I don't even know how to describe it. What? A mess. Okay. And so to get something done statewide would be pretty hard. It's amazing though, because you can go in conservative areas like Duval, Volusia counties, and pass ban the box ordinances with ease. But when you try to do something in the House or the Senate, it's just a logjam there. And so our best bet is just what we've seen so far in Florida is just to piecemeal it. And then if enough counties and cities were able to pass this ordinance, and we're also able to shift the political landscape, that we may be able to get something statewide within a couple of years.
I just wanted to say a real quick point about preemption in this space, which is something to be mindful of. Mississippi has, in response to a local jurisdiction passing ban the box, they passed state legislation to preempt municipalities from passing ban the box ordinances. So there is, I just want to raise that because there's always a concern, and legitimately in Atlanta around some of the things that are happening. We had a preemption bill this past session, so there's always this challenge about what happens when you take something to a legislature. And in a state like Florida, there might be some legitimate concerns about raising that issue before a very difficult legislature, just to see the possibility of the consideration that we don't like this policy at all, and how about we, instead of passing legislation to create ban the box, we establish it very clearly that no ban the box policies are enforceable.
Thank you. Oh, no problem. I want to transition to another legislative remedy. So one being record sealing and expungement, and want to see what the landscape in your state's in, and then overall have everyone speak on one, the importance of restricting criminal records in terms of alleviating collateral consequences, and what you see the landscape in your states coming up. We can start with Marissa.
Great. So Georgia is in a minority now in terms of being one of the states that do not allow convictions to come off of folks' records. There's a very limited exception for what we call youthful offender misdemeanor convictions. So certain misdemeanors are eligible for expungement, but the vast majority of people who really need the ability to have the record removed so they can move on are people who have been convicted. Georgia is still a state where you cannot get that done. So that is kind of our next step there.
Florida, that's not really happening in Florida. That's one of the frustrations that I've had as a person. First of all, I am a person who's directly impacted And so I have a couple of different views on the seal and expunge. But a lot of my frustration in Florida come with that illusion of seal and expunge and that false sense of hope that it creates in individuals who are directly impacted. And in Florida, there's a very short list of offenses that a person that will even qualify a person for seal and expunge, and even then, it's still not sealed, totally sealed or expunged. I mean, it's still there for agencies, law enforcement agencies, schools. As a matter of fact, if I own a plumbing company, the minute I contract with a public school, then I have the authority to lift that seal, you know. And so it's a really false sense of, or a false illusion that causes a lot of frustration, because when folks come out to get their records sealed and expunged and come to find out, well, first of all, you can't even have a conviction. You cannot get a conviction. So you don't even qualify. After only, in Florida, it's only an arrest. I think the bigger thing is now, and what I tell folks, and I could be wrong, you know, this is just my personal opinion, is that I wear my convictions and arrests like a badge of honor, right? There was a time when I used to walk around with my head down because of the things or mistakes that I've made in the past. But the same things that kept me down, and I'm a person of faith, and what I've learned is that God take those same things to lift you up. Some of the greatest people in the Bible are, you know, convicted felons and reprobates and all of that. But that's who God uses. And so I use that as, you know, and I tell people that, you know, well, just bear with me for a second. When President Obama finally went to get Osama bin Laden, right? And I tell people, he didn't send fresh recruits out of Fort Stewart, or, you know what I'm saying, or just came out of basic. He didn't send them. What he sent was SEAL Team 6, a group of hardened veterans that seen combat and came up out of that. Well, people with criminal records are like SEAL Team 6. We're the ones that's actually best qualified to, you know, create the change that our community and this country needs. And so we don't hide from that, you know. And so I tell people, why even try to seal it? Why even, no, you wear it as a badge of honor, because that creates a feeling as if we have to hide this, and we don't. We wear it as a badge of honor. So that's just my personal opinion. Florida is just really out of alignment with a lot of other progressive states, but my personal opinion is that I don't see that. I think the narrative needs to change. You know, when we talk about hindrances to reentry or successful reentry, it's more about changing the narrative and how you feel, because you can tell me that you support ban the box. You could tell me that you support me getting occupational licenses and stuff like that, but yet when I come to your church, I feel like, you know, like I shouldn't even be there, you know. And so I think it is a mindset that needs to be changed, because some folks, and I'm saying you guys, but some folks still want to call me an ex-felon, still want to call me an ex-con, you know, and the reality is that I don't go around calling anybody an ex-liar or ex-thief, you know. And so I think that we may want these things, but if the mindset don't change, right? If when you see me, you don't see ex-con, what you see is another child of God or another human being, then we won't need some of these other policy things that we think we may need to bring about change. It's more of a mindset and a narrative, I think, that really drives all that other stuff.
Monica, I don't have anything to add on top of that. So perhaps we can open it up to questions. Another question you have or the audience might have.
Can I respond really quickly? So I appreciate what you say 100%. Is Margie here right now? She's still here? Yes. So this conversation about sealing records and expungement and like, is that even a real thing? I agree with you in terms of this information internet age. It's impossible for lots of reasons once someone has gotten a record to get it completely wiped away. And so there is this conversation about, should we need to hide it anyway? But I would say that instead of that, there is a policy response. The policy response is to prohibit the use of criminal history information against a person unless, right? So this conversation about whether or not you see it or not, whether or not you know it about it or not, can we establish laws around how that information can be used, even if we know they're going to know it, and even if we know they're going to have it? And I would say, when we're talking to individuals who have been in the system, and you say, tell your story, don't hide from it, be who you are, say who you are. You are, in fact, more qualified than most for the position, will work harder, longer, stronger than most people that they are applying for. But if once you do that, if the stigma that you're a black man with a record is just something that they're able to continue to use against you, then no matter what your story is, if there's no laws that protect you, then we're in the same boat.
So,
do you disagree with me?
No, I don't. So then I think that might kind of explain why I can't get a job as a police officer, but yet the FBI can hire computer hackers to do their work.
Yes.
Cybersecurity.
Yes.
Because maybe the cybersecurity folks are white collar crime folks and might not look like me. Okay, maybe that. Okay, I'm just saying maybe that's why. Because I'm thinking why I can't work for Orlando Police Department, but if I was a good hacker, I could work for the FBI and the CIA. With top security clearance.
And what does community policing look like without y'all?
Yeah, right?
I want to kind of open up to questions if in the audience have any questions for the panelists. You can come to the mic and just state your name and then your question.
Well, I'm not that tall, but okay. I'm Vicki Henry again. Ban the box and expungement, that's just totally off the table for our families. But I wanted to direct the question to Mr. Mead. You mentioned the restoration of voting rights, and I'm really dismayed that people on the sex offender registry are excluded. And I know that that's not your decision, but they're excluded, and in these other issues, they're excluded too. So in our mind's eye, that's selective restoration and selective redemption.
Awesome. Can I address that?
Yes, you
can. I love it. That's actually a great question. So our position has been this. So first of all, let me just use this illustration. I have 4 boys and a girl, right? And any of you all that have boys, you know that eventually they're gonna do something real dumb, right? My boys do that all the time. I mean, to a point to where sometimes it's so dumb that you want to just feel like just grabbing them by their throat and be like, what the hell were you thinking? Y'all know what I'm talking about, right? Okay. But here's the thing, no matter what they do, they never stop being a Meade, right? They never stop being a Meade. When you talk about citizenship, nothing speaks more to citizenship than being able to vote, right? And so my position has always been that no matter what you do, you should never lose your rights.
That's right.
Right? That's position number 1. Position number 2 is, if I think that you're worthy enough to be released back into the community, then you should be worthy enough to have your rights restored as well, right? But here's the reality. Number 1, I live in the state of Florida, okay? And in the state of Florida, they tell me that I need to get 60% of voters to vote yes, all right? And because that threshold is so high, that dictates that I have to have multiple conversations with voters. Now, what we discovered is that Florida voters have a natural pushback against 2 groups of people, natural. Didn't even have to ask them who they don't like. They voluntarily told me who they don't like. They don't like murderers, and they don't like sex offenders, right? They don't like child molesters, and our women don't like rapists. They just don't. And when you include those groups, it says that only 35 or 40% of voters in Florida is going to actually say yes. And so I use the analogy of I'm on this cruise ship, and it's 100 of us on this cruise ship, and the cruise ship is going down, and it's only enough boats for 99 people. What do we do? And that's always been, a matter of fact, that's been one of those moral questions asked in law school. What do you do? Do you save the 99? Or do you let everyone die because everyone can't get on the boat? What we did was make sure that, and if you look at our language, that our language does not foreclose on the opportunity of sexual offenders or others to actually have their rights restored. Right? That process is still available to them. This amendment just creates a fast track for over 98% of the people who are impacted. And so when we looked at it, we was like, we're faced with a great opportunity. Do we allow 1.5 million people to be involved in the democratic process, or do we continue to have them shut out? And the answer, we took us an extra 6 months before we released our language because we really toyed over it, and we really do not believe in exclusion. But the political climate and the voters have dictated that we word our amendment the way it was worded. I hope that answered your question, ma'am.
And then, Desmond, for those who aren't aware, explain exactly who would get restoration under the Florida Amendment.
Everyone with the exception of individuals who were convicted of murder and individuals who were convicted of felony sexual offenses. And when we looked at the data from Department of Corrections and the Florida trial court system, and what we discovered was that everyone that's been convicted of any disqualifying offense accounted for 1.92% of the entire population of people who were directly impacted. And so because it was such a small section and our wording would not foreclose on it, we decided that everyone else would actually be able to have an opportunity to vote once they completed all portions of their sentence. So I hope that answered your question. Yes, I hope that answered your question. Yes. Listen, I am definitely not denying that, but that was a strategic decision to actually get this issue moved.
Would you have done that? Is your suggestion that given a lot of work in legislative reform and policy change is systemic, and so we have to make these kinds of compromises often, even though they aren't consistent with our belief system.
Yes.
Oh, I'm sorry. That was my fault. My only point with that is I think that to the point he raises, we have to make these kinds of compromises, and the only thing is to make sure that we are not betraying the group by saying right now the feasibility is to get this group in. We are going to continue to advocate for you. Yes. We are going to continue to try to represent your interests, and we're not going to stop right now. And
in addition to that, what I failed to mention was we had very deliberate and thoughtful conversations, not only with individuals that may have been on the registry, but also their loved ones, their parents and their wives, and the moms and dads, and we had some real tough conversations. But at the end of the day, some of our strongest, Miss Nancy in Orlando, some of those parents and those individuals was our strongest supporters out there collecting petitions to get this on the ballot.
Good morning. My name is P. Moses, and I'm from Memphis, Tennessee. And I'm not an attorney, but I'm a raptivist. And my question is to, I think it's Mr. McGrath, but I can't see that far. You answered part of my question previously, Mr. Mead, but I'm from Memphis, Tennessee, where things are really bad. Not much has changed since Dr. King has been killed. And as a revolutionary person, I have come up with a strategy which I think would work, and I wanted to get your opinion. I guess you're a lawyer based on what you said. We have a situation just like in Florida where several people are disenfranchised due to the felon laws. And I have all this data that basically proves that 1 out of 25 people in Shelby County, which is predominantly largest black city in America by population, cannot even be restored because they owe tens and thousands of dollars of court costs. So in July, there was a Supreme Court or a federal ruling that said it's unconstitutional to lock people up for owing court costs and fines and driving. Where in Tennessee, driving is a privilege. So I take the same position as Mr. Mead that it is not right for you to deny people the constitutional right to be considered and counted and vote. Could we do some type of lawsuit or some type of declaratory relief to get some type of either legislative change to get that done in the next 60 days? Because the most important election is going to take place in Tennessee, and I meet thousands of people that want to vote but can't vote and think that they can't vote because they're a felon, and this could really transform just the world. Is that possible? I'm willing to go knock on doors if we could get something filed to say it's unconstitutional for you to require people to pay money that they don't have, because a lot of these people are disabled, they're seniors, their charges are from 1960, 1970, before I was born, and they can't vote even though they want to because of court costs. Is that possible?
No.
Short answer, no.
So, if I could, Marissa, this is frustrating. It is frustrating to think about constitutional protections requiring the increment, even in court, never mind the legislature. It is a game of incremental advancements. But Thurgood Marshall knew this. And Thurgood Marshall litigated cases on an as-applied, on an individual-by-individual basis for 15 years before he got to argue Brown versus Board of Education before the United States Supreme Court. It is frustrating to see how long it takes, but it is a reality. The good news is that there are institutions that exist to address and take on these fights, and there are attorneys' fees when people win. So I think Governor Deal got it right to a large extent in knowing that perseverance is the greatest strength, and it is the strength that is necessary to advance on an incremental basis. I have the good fortune of working for an organization that sued Pagedale, Missouri, a town not far from Ferguson, a small little municipality with 3,000 people that were collecting fines and fees for things like barbecuing in the front yard and having screen doors that were ripped. They were generating more than 20% of the municipal budget by fines and fees. And currently we're suing Dorville, Georgia, just a few miles. How many miles, Marissa?
Maybe about 30.
30 miles north of here, an intersection of two highways in which the police are ticketing at a rate of revenue that also exceeds 20%. So fines and fees are a real issue that is being recognized by courts, but today the amount really has to be over 20% before a case is ripe for litigation. At the Institute for Justice, we gestate our cases in terms of internal processes and screening clients. That usually takes about 6 months to prepare the case. get the necessary internal approvals. Our time horizon, every case that we take is designed to go to a state Supreme Court or the United States Supreme Court. So we're looking for clients who want to hang around for 5 years.
But there is something you could do right now, which is to educate the community around who can vote and how to vote. There are mechanisms to get fines and fees converted to community service or other things, maybe even entirely. There are some folks here who might be able to help you think about some strategies for individuals who are interested in trying to register in time if possible. So even though there's not going to be a case that comes down in the next few years, and there probably won't be some legislation that you could get moving in the next 60 days, but you could start doing what you're already doing and just mobilizing communities and registering as many folks as you can.
And you can scare some people as well. So I think that, you know, a good example that you can look to is what happened in Alabama, where you had Pastor Glasgow doing some amazing work, informing people about their ability to vote, going in some jails and registering people to vote, and those people, returning citizens, formerly incarcerated folks, was able to not only go vote, but they take their friends to go vote. And we've seen a huge upset in Alabama. And then you also seen it in Virginia, where about 78% of the people whose rights were restored went and voted. And not only did they vote, they took their family members to vote. And so there is so much power that people have, even though, you know, we have this campaign in Florida called Your Vote is My Voice, right? And we know that even though someone might be disenfranchised, they can speak through the voice of their family members and friends who are registered voters. And when you do that in mass, you'll scare some people into doing the right thing.
I would just add to that Virginia example, and so we have a very difficult legislator in terms of getting a lot of these progressive reforms passed as well. And in terms of the voting rights, one of the things we were able to have succinctive Democratic governors who were very interested in the issue and kind of through executive order initiated a lot of reliefs. And so this past governor, or actually the previous governor, McAuliffe, he actually did away with requiring fines and fees to be paid as a prerequisite to getting your rights restored. So it could be an option, maybe not in 60 days, but it could be a more long-term option to explore.
I'm Marty Love, and I just want to say I love this panel, all of them. Angela, and thank you for the work you've done putting these panels together. It's just amazing. I agree with all three of you. Let me just speak for a minute to the fines and fees thing and voting. There's a professor at UCLA that's doing a study right now of the states that require payment of court costs, fines, and fees in order to regain the franchise. There was litigation in Washington State that actually did away with that requirement. And I'm not sure that there's not a possibility. You might talk to the ACLU or another organization that is in the business of challenging such requirements in court. I doubt, as Lee said, I doubt that you can do it in time for November, but there are other little strategies that can be, as you pointed out, Marissa. Let me just say that the reason I love this panel is that the three of you represent progress in the past year in getting legislatures to move and in getting people to move and in creative thinking and in patience and in determination to go one step at a time to fix this problem. And I am amazed. Someone said yesterday, I can't remember who it was, that it might take 4 generations. I don't think it's going to take 4 generations. I like the 15 years of Justice Marshall. You know, that's a little more realistic. It might be in my lifetime, maybe, if I live right. So thank you all for the work you're doing. I think that, it is a game of patience. It is a game of increment. I have never, in the past, really been an advocate for sealing and expungement. I think it does have a place. I think it's a hard sell when you get much above the misdemeanor level. I think that the idea, we've been talking to the Georgia Justice Project about sort of linking up the pardon system in Georgia to a record sealing type restriction. There are all kinds of, because Georgia's one of maybe a dozen states where the pardon mechanism actually operates. And so it's a really exciting experiment going through the states, and what the Institute for Justice has done in these red states, quotes, air quotes, is amazing. These laws in Tennessee, actually, the Fresh Start Act in Tennessee is enormously progressive. Their requirement of a $500 filing fee for expungement is not. So, you know, there are all kinds of wonderful things going on, and I really encourage everyone in this room to familiarize yourself. We try to kind of keep track on the Collateral Consequences Resource Center website of legislative developments, and there's so much to be gained by kind of creative thinking and looking for different paths and making alliances with people and organizations that perhaps you didn't think would be particularly supportive, but surprise, they are. And I love the SEAL Team 6. I agree with it, totally. I think that we need to present ourselves as incredibly creative and productive people. So anyway, that's all I have to say, and I am just overwhelmed with praise and pride for your work.
Thank you, Margie.
Thank you, Margie.
Let's see how you follow that.
I'm Mike DeLauro. I'm from Rhode Island. I've been working on expungement and sealing reform for more than 15 years. We're finally in a place where I think we're in a good place. And of course, it sounds like from what the panel has been saying that now they move the chains, right? Because the fact that these records don't, the public can't access them doesn't really matter anymore with the internet and all this stuff. So the next step, and a number of years ago, we worked with one of our local community organizations, did a comprehensive research from one end of the law books to the other on occupational licensing and business regulation, this type of thing. And what they found was that the number of automatic disqualifiers was really, there weren't very many. I remember the summary was like 50 pages, and all of the automatic disqualifiers were like in the first two. So my question is to the panel, what do we do about that, where a statute says, or rules or regulations that have been promulgated pursuant to law, what do we do when those say that a criminal record is a factor but not dispositive in the employment or occupational licensing calculus?
Okay. Mike, your estimates are right. There are about 15,000 collateral consequences across the nation related to occupational licensing, and 6,000, I shouldn't say only, 6,000 are the permanent bar. And so the approach that these 10 states have taken, including nearby New Hampshire, is to change the process, to flip the burden, to acknowledge rehabilitation and certificates of rehabilitation, to acknowledge family circumstances, and to make the process work on behalf of the petitioner, not on behalf of the licensees who are controlling new competitors. The good news, to build on Margie's optimism, one of the best things that's happening is we no longer talk about unemployment as a serious problem. We talk much more about not having enough workers. This invites the Chamber of Commerce to show up on your side. It invites NFIB to walk hand in hand with the lobbyists from the ACLU. And so the opportunities for coalitions have expanded.
And I would just say the problem is discretion. And I spend a lot of time on that today. I know I don't have time. But the problem is, you have mandatory collateral consequences and you have discretionary mandatory consequences. And what you're describing, I don't know where he went, where Mike went. Oh, I found him. Sorry. But one of the problems with discretionary to what you're describing may be a factor is that when you leave someone to their own discretion or a board to their own discretion as to whether or not it's going to matter to them, the chances are for the population of people that we care about that they are not going to give that person the benefit of the doubt. So instead of allowing them this kind of broad discretion, the answer is to do just what Lee said, to give process. So no, you can't. So the only way that a conviction or only convictions, but the only way that a relevant conviction or conviction can be used to deny a license would be in the following circumstances. And you want to say things like related to the recency elements. You want to build in all of the factors that you would want someone to, a licensing board to use, and then have a mechanism to appeal if that doesn't happen. So then you say, what happens if I still don't get my license? You need to think about what happens for folks. Is there a viable, affordable remedy for folks who have been denied a license in spite of those kind of factors?
One follow-up. Lee, you gave a statute number from New Hampshire a little while ago. Senate Bill 589 was signed by Governor Sununu on July 2nd. I'll give you the model legislation that was the basis for Senate Bill 589.
Good morning. My name is Stephen Saloom, and first I just want to thank NACDL for putting this on again. I think this is, for years and years and years, this is the single best convening for state criminal justice advocates across the country, and so I just want to thank you all for this. This is no exception here today. So I became a lawyer because I wanted to change the laws. I didn't want to argue over an unjust law. And I've been at this for over 25 years now, working in states across the country. And a lesson that things seem to boil down to is, well, number one, we've got to change the laws. You're either going to do it in court, which is not where I try to do it, or you're going to do it primarily through the legislature, sometimes through the executive. Either way, you've got a political process. You've got elected officials. And in the legislative process, which is where I've focused primarily, you have to get 50% plus one of the votes and get a vote in the House, and 50% plus one votes in the Senate and get a vote in the Senate, and then get the governor not to veto it, sign it by whatever forms. And the trick has been, we know the facts. We know the facts, and I can talk in the legislature about the facts, and I can talk one-on-one with anybody, and they'll say, oh, yeah, Steve, yeah, no, I know, no, oh, it's a shame, blah, blah, blah. But every legislator is thinking about what their own constituents are thinking back home. Yep. And because of the way districts are, just because of representation, just because of demographics, much less gerrymandering, to cobble together that 50% plus one in both chambers and get a vote in both and get it through is extremely hard, as we all know here. So, ultimately, I believe that it's legislators' perception of their voting constituents' perception of the issue that's going to determine whether or not they're going to vote for that. So to my question. On these issues, how do we talk about collateral consequences in ways that resonate with everybody across the state? How do we, and I want to really think about, how do we do it so that anybody would have to say, oh man, that's not right. They might not be able to picture themselves in that role, but they can see that it's wrong. And I welcome the panel's ideas about how we talk about this.
So I'm like, chopping at the bits, I'm smiling. I don't know if you see my smile from back there.
I did, yeah.
I loved where you were going with that question. And I think it's a very, very, very deep question. But before I get into the answer, I think it's two types of legislatures that you have to deal with, right? You have to deal with one that is basically bought off by special interests, and no matter what, even if their mother is going to suffer from it, right, that they're in bed with this special interest group, and they're not going to budge, and then that person you just got to get rid of. right? And then you have the other ones that actually buy into a narrative that it's a narrative that we as a group also buy into. All right, so I'm taking a long way around because this is so important. I think that's a very deep question. One of the things that you know, and I guess at the time I was saying it might have been controversial. It's not as controversial, I don't think. But during the time of the George Zimmerman trial, right, when this nation, folks all over the world was talking about, I am Trayvon, I am Trayvon. I mean, it was such a comfortable thing to say that even white people were saying, I am Trayvon, right? The president was saying, I am Trayvon. I thought that was like the easy way out. And that was not the way to go if we really wanted to deal with the issue. That if we really wanted to address that issue, we would have said, I am George Zimmerman. Because the reality is that it would have forced us to look at a condition that causes even me, as an African-American man, to look at someone that was dressed like Trayvon and think that he was up to no good.
Right.
You with me?
Yeah.
Okay. This talk speaks to a much deeper narrative that impacts, even in Michelle Alexander's book, it's amazing because she talked about a study that was done about how officers was showing the suspect with a bag of chips and soda and one with a gun, right? And the officers would shoot the black kid with the bag of chips over the white guy with the gun. But even the black officers was doing it, shooting at the same rate, right? Which leads me to talk about the book and I would encourage you to get it, African Americans and the Atomic Bomb.
Okay.
Right? Where they talked about how the United States, the only way that they were able to drop the bomb on Nagasaki and Hiroshima was they first had to go through a process of demonizing the Japanese people, right? Because if they were to just drop, but the African American community and the activists weren't fooled by that. And they were like, wait a minute, to have that much power to wipe out a civilization or a group of people, there's something inherently wrong with that. But what happens when you demonize or desensitize, right, the masses by having the Japanese people as those are the people that's going to rape and kill your wife and they're going to come and destroy America, then now when you drop the bomb on them, there's not so much of an uproar. You with me?
Yeah.
That's the same thing that's happening to African American men and women in this country, right? And so when you talk about collateral consequences, as long as that narrative is still out there that demonizes people of color, right, you're not going to get much movement around collateral consequences because these individuals are thinking in that stream of thought and not in a stream of thought that causes people to understand and listen, yes, it does impact you, and yes, you have a family member that is impacted by this. Think in that lines, because waiting on you to feel sorry for me, it's not going to happen.
Right. No, and so I'm totally with you. So what do we do?
So here's what you do.
That narrative.
Where do we? I want to start talking about
how do we first of all recognize that we also play that first of all the narrative impact us? Because see, let me tell you, this might be a little controversial, but that's Desmond. If me as an African American, right, during the Trayvon Martin, George Zimmerman episode, if I only kept it on white people, right, being racist and looking at Trayvon as a threat, I only get so far.
Yeah.
But if I am willing to stand up and say, you know what, even me, if I was in the street selling drugs and I see Trayvon coming, I would think he's coming to rob me. And if it was a white guy, I'm thinking that's one of my customers. Well, you understand? So the reason why I'm saying that is that we have some complicity in this. And we have to acknowledge it first. Okay. And we have to state it, because if we don't, then we're always going to operate from the sphere is that's that issue that needs to be fixed over there instead of it's a collective issue that needs to be fixed amongst us all.
Yeah. So the first step is to acknowledge the complexity of it, right? And how people feel about it, and let folks know that, like, we all share your base concern or the base concern. And then, you know what I'm saying? So I'm with you on that. And there's more, right? We gotta. I'm looking to go out tomorrow. You know, where do we? And so then what? And Marissa, maybe you're going to talk to that.
So I couldn't agree with you more.
Yeah.
I just would say when you're trying to think about incremental change and moving in legislatures that are, you know, where I understand Republican doesn't necessarily always matter, but it matters in the South and the states that I've worked in. It matters a lot when you're talking about criminal justice reform and who and why they're coming to the table. And so what got Governor Deal, he deserves all the credit that he's gotten for the leadership that he's had in this area. But what brought him to the table around the need to reform our system had very little to do and would not have been as politically feasible as a humanitarian, what are we really doing? How are we demonizing people? What kind of racial injustices are happening in Georgia? As happy as we all are about the changes around racial disparity in Georgia, it's relatively small, but had nothing to do with why we were in it. We were in it because we were spending $1.2 billion every year on our correction system. We had a 35% recidivism rate, and it was not spending taxpayer dollars responsibly. So what brought people to the table is fiscal conservatism. This notion of how are we using our taxpayer dollars? Does it make sense? What I mentioned earlier. In Georgia, 95% of the people that are currently incarcerated are coming home. So what sense does it make to have communities that are not able to receive folks and aren't able to think about how they might be productive members of society? So when we were talking to legislators about, you know, ban the box for occupational licensing or protecting employers when you're thinking about negligent hiring, is that when employers are coming and saying, look, I'm concerned, okay, yeah, I understand, you know, that everybody has a family, but at the end of the day, my bottom dollar matters, and I'm concerned I'm going to be opening myself up to all kinds of dollars and liability. So making the case that these kinds of things, can the states in some way protect you, indemnify you in some way so that you don't have to suffer those kinds of cost risks? And what we find is that even though we need to continue, and that gets to the same point we raised earlier about not betraying our work and the narratives that are so important to really transformative change, but while, you know, us at the Capitol now and down these legislators now, as we continue to try to make the world be what it needs to be, we need to start getting to people and talking to them in the languages that matter. And this whole piece around wasting taxpayer dollars, you know, putting our economies in the toilet because we're doing things that just don't make good sense, has been successful, I think, and it's why conservatives are taking the lead, if you will, on criminal justice reform.
Let me build off of Marissa's observation succinctly. When I have a meeting with a state legislator, my antenna is up, and I'm listening to, I'm trying to ask questions to solicit priorities of that state legislator. I go into meetings with Democrats wanting to talk about the fairness and equity for their constituents. I go into so everything is framed in that term. I go into meetings with Republicans talking about jobs and red tape reduction. It's the same bill.
I hear you.
Yeah, that's right.
Right. I want to thank you all because this is great. We need to get to just the heart of this. And one last thing, to pick up really on what you all said, we can all argue for the same reform using a whole bunch of different arguments. It's okay to use the different arguments to get together to that 50% plus one, and y'all just exemplified
What state are you in?
Well, I've done nationwide state-based work around the country, so I kind of like a remote support center for all
You want
sorts
to come
of
to Florida?
Huh? Yeah, I'll talk with you later. Okay.
But
Thank
you know, one thing, just really quickly, the one thing that I think that is so important, you are absolutely right. There's all kind of different reasons that folks come to this, and as long as it's the same bill and we can talk about it in different ways, we're fine. I think one of the things I mentioned around betrayal, and we are realizing it now more than ever, is this conversation about violent and nonviolent crimes. And for a long time, folks said, well, these we got to do something about people going to prison for we got a nonviolent, this conversation in some ways has betrayed folks, and this movement around people who have been working for decades on folks who have committed violent offenses, or what even violent means. So I think when we're having conversations and we're trying to identify narratives and positions that will garner support, we need to be mindful of the language that we're using, and whether or not we could come right back behind what we just said and advocate for the population that's not on the table right now.
Great point. Yeah, thank you all very much. Appreciate it.
We are going to have, so the last three people, if they can ask their questions very quickly and succinctly, and then we'll have our panelists answer very quickly.
Hey, Casey Taylor with Root and Rebound. This might be a little bit in the nuts and bolts, but we've been part of the coalition working on the occupational licensing bills going through the California legislature. And one of the issues that's kind of come up that I'm not sure if I missed, but is around the self-disclosure requirements that a lot of the licensing boards have, and that it creates a trap for people who don't know what's on their record, don't know what they have to disclose, and then also have to justify why their version of the events is different from the police report. So I am wondering if there's been any success with an elevation of that issue within reforming occupational licensing and just how people have to disclose generally.
We'll have every person will answer their
Okay.
question, then they'll answer
Thank
at
you.
the end. Thank you.
My question is, I'm a criminal defense practitioner, and I've noticed you guys were talking about the employment hurdles in reentry, but have you guys noticed any push in legislation as far as the restrictions with housing when people come out, as far as Section 8 or not being able to get student loans and those things that also kind of impact reentry? So I want to know if there's any legislative push on that too.
Guess this is going to be a lot to group together. Good morning, everybody. I'm not
Very
even,
quickly.
I'm not even really sure how to frame this into a question, so just kind of run with the afters. I'm wondering how we can push this room of jurists as activists and organizers. We already do it, but the room of jurists. You're too tall. I'm sorry. Hear me better now? How we encourage our jurists in the room to be more activists on these issues. I was able to be in a room of judges who were being pushed to be more activists because they're at the butt end of policy. We have politicians shaping policy. We have politicians who have no background in this stuff. They got enough votes. That's it. So how do we get our jurists who are skilled and practiced in the language, the letter, to be more activists, to help us as organizers and activists? Thank you.
Go ahead.
So we are up against time in terms of giving you guys a break so that we start the next panel on time. I'm going to answer your question really quick and then allow the panel to answer the other questions. The next panel is on judges and prosecutors, and I know that Judge LaGrua, is Judge LaGrua now, has done some stuff with the violent offenders, so she may be able to answer that in terms of them being active. Dave LeBon, who you're sitting right next to, Dave's only going to be on the hot seat. Dave, I love you. So we'll hold your question for the next, so they may be able to answer some of that, and I'm going to turn it over to you guys to answer it like in 2 seconds. The other two questions.
The self-disclosure piece around ban the box, that came up in Georgia. Legislators were saying we don't want to codify lying. That this notion that employers should be able to ask. So I just we know that some states have done that. Some states have passed legislation that prohibits the ask of the question. Unfortunately, Georgia is not one of them. The person who asked questions about other collateral consequences beyond employment, there is definitely conversations and movement around some of those reforms. The focus to date has been on this notion about the single biggest predictor of recidivism is whether or not someone has a job. I would say house, right? Job and housing. So those have been the primary focuses, but there have been changes to food stamp ban and some other child support and some others in Georgia that would be relevant to what you asked.
Yeah, so there's some piecemeal work going around in Florida around the other collateral consequences. Our organization in particular is focusing primarily on just restoring voting rights with an analysis that with voting rights restored, we can become even more active in our communities and create greater power within communities of color to change these policies or put people in office that think like us. And to answer that other question is, I like to use our brother in Louisiana, Norris Henderson, with Voice of the Experience, right? And I encourage you practitioners to think about running for office, because we will put you in office so you can judge justly, right? So that's how you can get involved, by being bold enough to take it another level, to be our people who preside, be that person who presides over trials. Because all of those folks are elected, at least in the state of Florida.
And I would quickly add in terms of other collateral consequences, because even though we're talking about some of the regressive reforms, we need to be careful of regressive attempts to roll back some. And in Congress, when they return after the recess, they will be considering, the House and Senate have to come to agreement on a farm bill that includes some regressive restrictions on SNAP benefits. And so that's something to look out at the federal level in terms of following some of the regressive pushback we may be getting as well. So I want to thank our panelists. We can give them a hand.